name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing homeowners associations and condominiums for the past 24 years. In May, it'll be 25 years, can't believe that. My firm currently represents over 1,000 associations throughout the state of Arizona, and that includes planned communities and condominium associations. And I also serve on my HOA board and have for many years, over 14 years now. Joining me today is a lawyer in our office, Lauren Bai. Lauren's been with our firm for the past 5 years, and any of you who know Lauren know that she is such a hard worker and has a wonderful, inviting and bubbly personality. Lauren is a graduate of ASU, and she has been with our firm for over 5 years now. So we're going to tag team when we do the questions on First Fridays. So welcome to our first virtual First Friday free call-in. I can tell you already by looking at the numbers that have joined us here this morning, that is going to be a success. Thank you for joining us on Good Friday today. We appreciate you being here. And so over 15 years ago, our firm started our popular and helpful First Friday free call-in. And we've been doing it for many, many years, as you know. And we really enjoy having the opportunity to connect with you personally on a phone call. However, this month we decided to try a virtual First Fridays and to see how that would work this month. So managers and board members have loved this opportunity to ask a free question each month. And of course, we've always enjoyed connecting with you personally each month as well. But based upon the success of our firm's Q&A sessions on our recent virtual seminars, we decided this month to try a new virtual format for the First Friday free call-in. And this is going to enable us to connect with you and answer a larger volume of questions in just a shorter period of time. During the first portion of First Fridays Live, I'm going to be discussing the Governor's of Arizona's new executive order. We're going to be talking about what are some common sense rules to navigate this unusual time, pros and cons of conducting in-person or virtual board and annual meetings, and how the vaccination of residents will impact your association going forward. So let's get right into it. Let's talk first about Governor Ducey's most recent executive order. I think all of us were very surprised last Thursday, March 25th, when Governor Ducey issued a surprise executive order lifting all COVID-19 business restrictions in Arizona. And my team will be sharing the governor's full executive order with viewers on the screen shortly. You also can obtain a copy of the executive order by just Googling Governor Ducey executive orders and then looking for the one that was on their website from March 25th. There's an actual tab that lists executive orders. Okay, so what does this mean for associations? So all business restrictions in Arizona have now been lifted. So despite the governor lifting all of these business restrictions, it was interesting that the executive order encouraged all businesses, and this would include HOAs and condominiums, to continue to take precautionary actions that are recommended by the CDC, United States Department of Labor, OSHA, and the Arizona Department of Health Services in an effort to continue to limit and mitigate the spread of COVID-19. So I think that the sign here was that the governor wanted the state of Arizona businesses to get back to business as usual. However, they still want businesses to take these precautionary actions as recommended by these state and federal agencies. So it's kind of a mixed message, right? Let's open everything up, but still follow all these precautionary actions. So let's talk about what are some common sense things that your associations can do as we navigate this kind of mixed message order and this really unusual pandemic time. So first, let's just cover that, HOAs and condos still have the right to pass and enforce rules and policies in your association that would mitigate the spread of COVID-19. And those type of rules that we're seeing many associations continue to keep in place are that owners are required to use face coverings, that owners should, keep social distancing in place, 6 feet between anyone that doesn't live in your residence when you're on the common areas. Using virtual meetings, all of these are good suggestions for associations as you continue to navigate this time. And we're going to talk a little bit about A question that I'm getting a lot this week is, well, can we start meeting in person now that the governor's lifted the restrictions on, gatherings of 50 or less persons? And we're going to talk a little bit about that in a minute when we talk about the pros and cons of a virtual meeting. So just bottom line is, associations, you can still have your own rules, even though the governor may have taken away the state mandated rules, while they continue to encourage people to, follow these federal agencies' restrictions or guidelines for limiting the spread. Okay, one question that we had immediately after the governor's executive order is, what about the pools in associations? The governor, when he did his last executive order, maybe 2 or 3 weeks ago, it was very unclear as to whether the restrictions on pools in associations were lifted, even though he had lifted like water park restrictions. And so it's very clear now with the governor's executive order from last week that the executive order that was previously passed many months ago, which limited the number of residents that were congregating on HOA or condo pools, is now lifted. And so, but again, it's important to note that HOA and condo boards can still implement pool rules, including if you want to limit the number of residents at the pool. Maybe you still want to have a limited number of pool furniture, or maybe you want to, limit large gatherings of people, parties, that type of thing, requiring people to wear face coverings when they're not in the pool, and social distancing. That's still okay because you have the right to do that under, your rulemaking authority and your documents. And we are recommending that. I've been getting a lot of questions. Sometimes the whole pandemic thing is kind of crossing party lines, and I'm not going to get into any political things, but I am going to get into health and safety issues and limiting association liability. And while things have been lifted, we still need to be cautious as we're reopening our associations and taking a wait and see approach because, there's a lot of unknowns on the vaccination, which we're going to talk about in a minute. Okay, so what would be some common sense rules? I think that if your association is reopening your gyms, your clubhouses, your pools, that your board should be meeting to discuss, what particular restrictions your association wants to implement. And I think some good guidelines would be to look at what the CDC website recommends. You should be making it mandatory that owners are wearing face coverings except when they're eating or if they're actively swimming in the pool. I think that you should have signage, at the pools, reminding everybody of these rules. I think these are just all good suggestions. So many of the things that you may have already had in place, you may continue to keep in place, at least for the next few months as we navigate how the vaccine is going to be effective against many of the new strains that are coming into Arizona right now. Some questions we're getting in our firm are, should we be meeting in person now? Can we meet in person as a board? Should we continue with virtual meetings? What are the pros and cons of in-person meetings versus virtual meetings that we've learned as part of this pandemic? So I guess the first question is, can we meet in person now as a board? Because the governor has lifted the restrictions on the gathering of owners in your association or just public gatherings of 50 or more, you certainly can choose to meet in person right now. And I have some associations that are really itching to do that. If you are going to do that, just be mindful of following CDC guidelines, and making sure that people aren't congregating before or after, and just giving friendly reminders that, hey, we're still in the middle of the pandemic, hopefully nearing, the middle to the end, and we need to be careful if we are going to meet in person. Should we continue with virtual meetings? I have other associations that are going to continue with virtual meetings likely through, the second and third quarter, maybe even the fourth quarter of 2021. And honestly, that is the safest way to continue meeting as a board. And it's working. I think we're going to talk a little bit about what are the pros and cons for associations that have used virtual meetings during this time. And there are a lot of pros. And I think kind of what we anticipate for the future for many associations is that there's going to be a hybrid of virtual meetings and in-person meetings. And some associations will just continue entirely with virtual meetings going forward because it's working so well for their community. So I think we're just going to have to look and see what works best for your association. If you are going to meet in person, just make sure that you're following the CDC guidelines. What are some pros that we've seen from virtual meetings over the past year? One of the pros I think that is the most incredible thing was how quickly and easily most associations were able to transition to a virtual format, a format that honestly none of us really had ever used before. And I think it's really commonplace now. Most associations are using this. Most management companies are using it as a preferred means, and likely will probably be writing that into their contract, that this is something that they're going to want to do more than less in the future. Some pros were ease and of use and ability to adapt quickly to use the online platforms. Some other things that we saw that were pros are the meetings appeared to be more efficient and shorter. And there wasn't a lot of, inefficient use of time. What I would say is that people get in and get out of these meetings quickly now, and we're accomplishing a lot. One thing that I noticed as a lawyer that represents associations is that associations saved a lot of money in legal fees, because if you have your lawyer attend the meeting in person, you're paying for them to travel to the meeting. And with traffic in Arizona, I think we all can agree that, that might be an hour for the lawyer to get from their office to your meeting. So the smaller legal fees were the result of the lawyers are only charging for the actual time that they're on the Zoom call, which, sometimes is as short as 10 minutes, sometimes, as long as an hour. But you're not paying, double with the travel time, so to speak. Also, I found that there was more flexibility for lawyers, vendors, interested parties at a meeting to join at the last minute. When I went to meetings in person, there really wasn't that flexibility. It would be difficult for me to get in my car and drive to wherever your meeting is. If at the last minute at 7 o'clock, the meeting starting at 7:30, I might not make it in time. And so with Zoom, what we did with a lot of clients, and a lot of clients had, the ability to just say to somebody, hey, can we put you on reserve for tonight? And if we need you, we'll text you. Can you just hop on Zoom quickly? And I've done that so many times, or maybe a manager has texted me while they're in the middle of a night meeting and said, hey, are you available? Can you hop on our meeting? So it gave flexibility to get questions answered faster and to deal with problems immediately by allowing your lawyer to join by Zoom. More people participated from off-property, off-site owners, out-of-state owners. Also, we saw that off-site owners agreed to be board members. So that gave us a new candidate, a pool of candidates that could be part of your association's board. So overall, I think the pros, there were a lot of pros for using the virtual meetings. And I think this will continue through post-pandemic as well, to a certain extent. Some cons that we saw for using, virtual meetings during this pandemic it took more planning, definitely, for regular board meetings and annual meetings. The manager or whoever was planning the meeting really needed to be on their toes and making sure that, the Zoom information was provided to the homeowners, that the board members had their packets at their fingertips prior to the meetings. Some other cons I would say would be it's harder to get a quorum, we found, at the annual meeting. It wasn't impossible, but we really had to keep our finger on what are the numbers, 2 weeks before the annual meeting, a week before the annual meeting, 3 days, 2 days, 1 day before the annual meeting, to make sure that we did have a quorum. And I don't really know why. I guess maybe an argument could be made that some people just didn't want to go to an annual meeting by Zoom, or maybe there were some technical difficulties. People were reluctant to embrace virtual technology. Or maybe things, were just running really smoothly. And we've noticed this since the mail-in ballot statute went into effect many years ago. We had less participation in person at the meetings when people could just return a mail-in ballot and have their vote counted that way. We saw some owners and boards that just didn't want to participate in virtual meetings. And so whether it was a technology issue or whether they just didn't like the format. So there are a few. I would say the numbers there are fewer than the people that enjoyed coming to the meetings and were, more likely to come to the meetings if it was virtual because they could come from anywhere and they didn't have to leave work, etc. Another con is the loss of personal contact. I know that I personally really miss seeing all the board members that we work with. And, I miss teaching these classes that I taught for many, many years, over 20 years with neighborhood services throughout the state and then the seminars that our firms put on. I miss seeing people there, and a lot of people, miss that personal contact of talking with their board or resolving problems face to face. So, that's been a con, obviously, of having to go the virtual meeting route. So overall, I don't know what the future is going to hold for associations, but I do think that there's going to be a hybrid use of virtual and in-person meetings going forward as a result of the pandemic. Okay, let's switch over and talk a little bit about how vaccination is going to impact your association. So let's start out by just saying there's a lot of unknowns on the vaccination. There was an article this morning in the Arizona Republic that was talking about how effective the vaccines are. With regard to these alternate strains that we're seeing coming into Arizona, and, is it 98% effective? Is it 87% effective, 75% effective? How will the vaccine hold up over time? Is it going to last more than a year or 6 months? And so a lot of these questions are unknown right now, and we wish we had the answers. We did see something that came out literally just minutes before we went live today on Zoom and Facebook Live, that the CDC issued a statement saying that fully vaccinated, residents in the United States could do domestic travel now without worry. So that's obviously moving in the right direction. But like anything over the past year, we've seen, shifts in, how things are handled by our government and the regulations and the guidelines. So we'll just have to wait and see what happens as this pandemic progresses and as the vaccination rollout continues. So a question we're getting in our office is, so can we ask for vaccination proof? Is that something that we can do? It's our opinion that you certainly can ask for it, but the owners are under no obligation to provide it to you. And frankly, I would be very cautious and reluctant to get into requiring vaccinations as proof to use common areas in the future. It could be seen as an invasion of privacy. There could be some constitutional issues with that. And we're already hearing about that, right, with the passport, vaccination passport, that there are some groups that are concerned and upset about that. So I wouldn't be advising any of our clients to be asking for vaccination proof or requiring vaccination proof to use common areas. I haven't heard of this in Arizona, but I have heard of this in other parts of the country where large associations are being used as vaccination sites. I haven't heard that yet in Arizona, but I have seen that around the country. So that was kind of an interesting concept. Another question that we've been getting about the vaccination is, residents are saying, I'm vaccinated and I don't want to wear a mask and I don't want to social distance and I want to have a raging party at the pool this weekend and there's nothing you can do about it. And that's kind of creating some, unique issues for associations, because how do we handle that? Yes, it appears that, because owners can travel domestically, because they're vaccinated, without risk. But notice if anybody's traveled recently, they're requiring social distancing and mask wearing. And so I think it's what we just need to reiterate to the owners that are ready to party is that we are able to still make rules in our association. And if you are planning to, socialize, you have to wear masks if you're on the common areas. You're welcome to do what you want on your own property. But in the association's common areas, we have rules and you need to abide by those rules. Okay, so that's just kind of a brief update on the latest COVID things and what's going on in the state of Arizona. I'm sure some of you may have questions about what I said, and once I get through the update on the Arizona legislature, we'll get right into the questions. Okay, very quick update on what's going on in the Arizona legislature. This has been a really unusual year, another unusual year in the Arizona legislature. There have been no bills that have been signed by the governor as of this morning, regarding HOAs and condos. And I've been following legislation for 25 years for my clients, and I really enjoy it. I love to see how legislation is made pertaining to associations. This year is just unusual. Our legislature is spending obviously a lot of time dealing with COVID-19 issues and hot political hot button issues, and less time on association issues. So I've never been big on government regulation of associations. So having a break in 2020 and possibly a break in 2021 on new legislation pertaining to associations is a good thing. I wish that some of the bills that we really need to correct problems, I wish those were on our table right now, and that we would be talking about those as bills that are moving forward. And it's unfortunate that we're not seeing regulation of short-term rentals this year, any significant regulation of them. We're going to talk about a small bill, but it's not the bill we want. The bill that we hoped we would see again move through the legislature on, taking away the association's responsibility to provide a statement of account to every owner monthly. If you're collecting assessments monthly, that's not on the table as passing this year. So some of the bills that we really want, it's not going to happen this year. So here's what we've got. I'll give you a quick little 411 on here's are the bills that we're going to see likely come into play here in the next few weeks. So just as a primer, the legislature opened on January 11th. They're scheduled to adjourn on April 24th, 2021. Some bills that we're watching just yesterday, Senate Bill 1377 was sent to Governor Ducey. This will apply to associations, HOAs, and condos, but it also applies to all businesses in Arizona, whether you're for-profit or nonprofit. And basically what it says is that it limits liability for Arizona businesses for COVID-19 lawsuits. So if the association, HOA, or condo is sued by an owner or a resident or a guest because they claim that they contracted COVID-19, or maybe a relative passed away because of COVID-19, the legislature is now mandated, or they sent this bill to the governor, and it's anticipated, I think, that the governor will sign it. The governor's a business person. He's former CEO of Cold Stone Creamery, and I think he understands, the risks that businesses are facing with the pandemic. But basically, in order to prove that the business has liability, the plaintiff would have to show that there was gross negligence or willful misconduct, and that is a very high standard. And I think it would be difficult to prove, especially with the causation issues. Like, how can you prove that the association's gross negligence or willful misconduct caused an owner to contract COVID-19 or die from COVID-19? It's very difficult to prove that. So as I said, this is on the governor's desk. We saw a number of other states, probably 5 or 6 states last year, pass bills with this same language. And I do think the governor is going to sign it into law, and that will be helpful to associations because, as we know, there likely is no insurance coverage under, the infectious disease, limitations on your insurance policy that were a result of the SARS pandemic several years ago. So that's a good thing for associations. Some other things that we're following this year, just very briefly, first responder flags. Associations, HOAs, and condos wouldn't be able to prohibit first responder flags. I think that could pass this year. I'm going to put this in like the likely to pass. It's moving quickly. Peaceful assembly on common areas, private or common areas in an association, condo, planned community. This is politically charged bill, of course. I don't know if this will pass this year. This is controversial. Allowing peaceful assembly on non-HOA issues and HOA issues. It's just unusual, and it's a sign of the times. Also, as part of that bill, political signs would include election or recall of HOA condo directors. Just unusual that we would have political signs on people's property mandating that they should be allowed to have it for HOA elections or recall elections. I think that could be a little messy in the future, but we'll have to see what happens on it. The ability to collect attorney's fees on garnishments, that's a good bill. I really do hope that passes this year because that'll be helpful to our clients. We have a bill on short-term vacation rentals, but it's not the bill we want. Basically, what this bill says is that landlords have to provide contact information to the city, town, or municipality, and they must maintain insurance. And then there's some penalties if they don't do that. I mean, that's not the bill we need, right? We need a bill saying that cities, towns, and municipalities, should have the ability to limit short-term rentals. So anything less than 30 days, what the law used to be back in 2016. We're not seeing that, but having been a seasoned lawyer watching these different 25 years of legislation being made, I think probably what's happening here is that everybody knows short-term vacation rentals is a hot topic. Even the governor was talking about this in September and October of 2019, saying, hey, this is a legislative priority for me. That was before the pandemic hit and everything changed. I think what's going to happen is we're going to get a watered down short-term vacation rental bill this year. And then every year thereafter, they start building back on it. They know they can get the support for the watered down bill. And then next year, following years, we will start to see, more strict regulations, hopefully to go back to where we were in 2016, where cities, towns, municipalities, counties can regulate short-term rentals by ordinances and by zoning, versus the way it is now, which is the law now that associations have to pass a CC&R amendment to get short-term rentals restrictions in place. Another sign, political signs can be left up longer after the election. So it would be 15 days versus 3 days, which is the law right now. And so, again, another sign of the times. So again, just in closing, we're closely following what's going on in the Arizona legislature. I don't think this is going to be one of those, shocking years where there's so much new legislation that, it's crazy. We have to have some sort of special seminar and debriefs and lots of questions. What I would encourage you to do is it's game time now. We're in the last 3 weeks of the legislative session. This is when things start to happen in the legislature. So be sure to check out our webpage, mulcahylawfirm.com, between now and when the legislative session ends. And we will be putting out a legislative summary like we always do. That will also be on our website, mulcahylawfirm.com, once the legislative session is over and all bills have been signed by the governor. So stay tuned. We'll also be talking about this at our next Facebook Live and Zoom conference for class number 4 of our spring 2021 virtual HOA Academy and Condo Academy. And that will be held on Tuesday, April 20th. And at that meeting, we're going to be talking about how to work with your association's vendors effectively. If you need any more information on our upcoming classes, please visit us at mulcahylawfirm.com, which is our firm's website. And our team is right now planning the second half of 2021's virtual classes and also hopefully some in-person classes. So stay tuned. Be sure to keep checking our website as we continue to update you with our seminars and classes that we'll be teaching in the second half of 2021. Okay, so we're going to start the questions now. And I am going to maybe have Lauren help me a little bit with the 1 and 2 here on the reopening questions. So I'm going to switch over, and how we're going to work the First Friday questions is it looks like we have a lot of questions, over 50, which is amazing. So we will reread the question. We're not going to use names for privacy purposes. And then we're going to give the answer right after it. And so Lauren and I are just going to kind of go back and forth. I'm going to let her take these first 2 questions on reopening common areas as per the governor's order. And so I'm going to hand it off to Lauren.
Hi, everybody. Happy First Friday. Okay, so I'm just going to jump right in. So our first question is, board members are wondering if we could expand a little more on opening of pool amenities. And this this board member notes that Governor Ducey didn't really specifically mention pools. We noticed that as well. Even though Governor Ducey didn't specifically address pools, the order right now as it stands hasn't addressed pools, but we do think that you can start opening a little bit. He's gotten rid of the occupancy limitation as the last executive order. So you can open it a little bit more. We do still recommend, obviously, the association itself have guidelines in place regarding sanitization if that's something that you want to do. You can also still implement your own occupancy limitations if you feel that that makes you more comfortable or makes your homeowners more comfortable. But you're correct, Governor Ducey didn't really address that, but he didn't address pools specifically, but he has addressed occupancy. Our next question, okay, is there inherent liability to return pool furniture to the open pool area, open the restrooms at the pool if we don't have an on-site staff to manage them? So is there liability? Potentially, but what we recommend we recommend this to all associations that have pools, common areas where people congregate right now. You need to put a sign in place that notifies the homeowners that they are essentially entering this area at their own risk. COVID-19 could be present, and that they are assuming any liability when they enter this space. We actually have language that you can use on a cheat sheet on our website. You're going to hear me say this a lot because we give you a lot of fantastic information on our cheat sheets on our website. If you're in between First Fridays and you have a legal question, we've probably answered it on a cheat sheet. So please refer to our website. In this case, we have a cheat sheet regarding opening and closing common areas during COVID. And we have language specifically that you can put up in your association that basically states COVID-19 could be present. The homeowners are entering the area at their own risk. We ask that they remain around people who they live with, try to avoid engaging with other homeowners who they don't live with to limit the spread of COVID, washing their hands, making sure that they stay far enough away from people. But there really is no rule in place regarding the implementation of pool furniture or putting it back in. Again, I would say do what makes you feel comfortable. If you feel that you want to put pool furniture back into the area, but you want to space it 6 feet out or 3 feet, according to the new CDC guidelines, that's fine. You can kind of take the temperature of your community and figure out, what does our community want? Do they want all the furniture back? Do they feel comfortable with that? But the board can meet and discuss what they think is best for the community. And then, like I said, have that sign up there. Make sure that you have a sign at all of the entrances to the common areas, even inside the bathrooms if you can, making sure that homeowners are aware that they are taking a risk by entering this area and that they assume the liability for doing so.
One thing that I would just say too is I love the enter at your own risk on those, because obviously, just having that sign is an extra precaution. And letting people know if you're not sanitizing the furniture, make sure that you're letting them know on that sign. Okay, let's talk a little bit about, is it appropriate to ask members and their family and guests about vaccine status? So I kind of briefly touched on this in the beginning. I do not think it is appropriate. I mean, of course you can, and a lot of people are very willing to share that information with you. But like sending out, if you did like a poll of your community that was anonymous, I'm fine with that. But making it mandatory that in order to use the common areas, you have to show us your vaccination card with both doses or one dose if you have the Johnson & Johnson vaccine. We don't think it's appropriate. And we think there are some constitutional issues there. And so we're recommending that associations not get involved in that. What about for activities? What is the recommendation for the size of participants for dances, shows, food, events, classes, bridge games? I'm hearing a lot of these questions from associations now. It just really depends. I mean, try your best to have as many activities as possible outside on your common areas. And, like I had an interesting question from an association that we represent this week, where they wanted to have like I can't remember what they called it. I think they called it like a pandemic bash or down with the pandemic or something. And they were going to have, this was in the Sun City area, and they were going to have like potentially 200, 300 people there. I just think that is not good judgment. What I would recommend is try to have things outside as much as possible. Look at the room space that you have, the clubhouse space. Some of you have amazing clubhouses that are very large and it's possible to social distance. Some of you have smaller areas with not a lot of ventilation. So you're just going to have to look at it on a case by case basis. But, for like dances and shows and food events, I think extreme caution should be, over the next few months. I really do think that there should be extreme caution on part of associations. So we have to look at it on a case by case basis. The governor's lifted the restrictions, and I'm sure that there are some associations that are going to say that, listen, the governor lifted them. We're okay with taking the risk. And if that's okay, just make sure that you're following CDC guidelines, that you're publicizing things like wearing masks, social distancing, make sure there's proper sanitization, making sure that the food vendors are following CDC guidelines too, and just re-enter this unique time with caution would be my best advice. Okay, I'm gonna switch it over to Lauren.
Our next question asks, we are moving on to everybody's general questions, not just questions about the governor's recent order or COVID. So this question is, if you have a CC&R rule of no parking on the street overnight, but in 22 years, it has never been enforced, is it enforceable now, or can the rule be deemed obsolete at this time? So this rule can be enforced now. It's not necessarily waived by non-use. Homeowners may argue that. I actually recently had an issue with a client where they didn't enforce a rule for 41 years. And the board decided to reinforce that rule. It was their how they calculated their assessments. And they actually had a homeowner that ended up filing an action with a judicial body saying, hey, we think this rule is waived. And that judicial body ruled that that rule was still in place, even after 41 years of non-use, because that's specifically what the declaration says. Courts give effect to the language that we have in contracts here in Arizona. Your declaration is a contract, so courts are going to give effect to that language. So I think this rule is still enforceable. Now, obviously, since you haven't enforced it for about 24 or 22 years, what you can do is you can basically notify the homeowners that you intend to enforce this. It can be a fresh start for this board. You're going to right the ship, enforce the governing documents the way they're written, notify the homeowners that the parking rule is going to be enforced, maybe give them a little bit of a grace period, say, hey, next month or in 2 weeks, we're going to start enforcing these rules. Please be aware of this. And then you can move forward with enforcing that rule. But we definitely think that you can move forward with that. So the next question is, can the board impose a capital fee without membership approval? No. So sometimes these are referred to as transfer fees, capital improvement fees. We see all kinds of names for this charge, but essentially it is a fee that the association can charge when title transfers to a new owner, and the new owner pays the amount specified in the CC&Rs to basically, usually the funds are used in your reserve funds or they're used in your capital improvement funds, but they're used for your big projects. If you're repaving a parking lot, if you're trying to fix the roofs, if it's a maintenance project down the road. So it's a really helpful fee. We really do recommend that associations have these fees, but it absolutely has to be in your declaration. The board can't implement this rule on its own. You've got to put it in your declaration. And if it isn't already in your declaration, that means your declaration has to be amended and you have to get homeowner approval. The exact amount of homeowner approval that you'll need to get is going to be in your CC&Rs. So you need to look through your CC&Rs and see if you need 51%, 67, 75. But if you need assistance with this, drafting a transfer fee, capital improvement fee provision, we can certainly help you with this. We do this for associations all the time. We really do think they are very helpful fees to help build up your reserves and ensure that you have money for these big projects in the future.
It's really nice to have somebody on your team who answers it better than I even would have answered it. So great job, Mark. Great job, Lauren. Okay, next question is on the architectural committee. And what do we do if we have kind of a bad architectural committee member? So the question was, their entire board serves as an architectural committee, which is really kind of how we see a lot of associations operate right now. And one of the architectural committee members has stated the homeowners can do whatever they want on their property and often doesn't respond to ACC requests that the board is asked to approve or deny. And so what options does the board have when we have one member of the architectural committee who really just does what they please and doesn't respond? can't keep up with emails, no idea what the issue is, and it's really kind of holding up the process and potentially making it more difficult for the board to do their job. So I guess what can be done to remedy this problem? Well, first, you have to look at your bylaws because they're your CC&Rs to see who has the authority to appoint the architectural committee for your association. Now, as you probably know, a board member must chair the architectural committee under Arizona law. But typically in the bylaws or in the CC&Rs, it'll state how the architectural committee is appointed. Very unusual that they're elected. Usually that's not the case, like maybe 1% of the time we see that. So typically the president appoints members to the architectural committee, or maybe even a majority vote of the board. And the power to appoint and then the power to remove is typically then granted in the documents. You have to look and see how that's done. I think you would be well within your rights to vote to remove this person as a member of the architectural committee, as long as your documents allow you to do that. The more serious question is, okay, this person's still on the board though. And so this kind of crosses over to, hey, is this person a good board member too? And I don't know if they're an officer. You typically in the bylaws of every association, you can strip somebody of their officer position by a majority vote of the board. But in order to remove a director from office, you are going to have to go through the entire process. The removal process is outlined by Arizona law, and that is on our cheat sheet, the top 10 things you need to know about community association law. It's number 6 on the flip side of that cheat sheet. So this is definitely a difficult situation. What I would do first is talk to the board member / architectural committee member and explain to them what their responsibilities are, and that they have to respond, that they have to uphold the CC&Rs, and when he's not responding, he or she's not responding, and not keeping up with the emails, it's delaying the process and making it more difficult for the association to do the job, and also making it harder for the owners to move forward with construction projects that they want to do. So try to be nice first, talk it through with them. If that doesn't work, then look at your documents, and likely the majority of the board or the president will be able to remove the architectural committee as a member of the architectural committee. And in the future, you may want to make this group a little tighter and smaller, and just have a couple people on the architectural committee, but make sure you still do have one board member that's chairing the committee. Okay, I'm going to move over now to Lauren for the next question.
How would we recommend that boards communicate and share information with homeowners between board meetings? Is social media an option? Is there any public guidance on how to use social media if you're a homeowners association? Basically, we can definitely communicate with homeowners in between meetings. We recommend it, honestly. One of the best things boards can do to put homeowners at ease, to help with the general happiness in your community, is communicate with your homeowners. It is so, so important, and it puts them at ease. So we definitely recommend communicating in between meetings. Obviously, you want to make sure that the communications are appropriate to be sent out to them. You want to make sure that you're not jumping the gun on something that needs to be decided at an upcoming meeting. But if you're just trying to make them aware of, let's say, a community event, or remind them of some rules that you're seeing maybe are being violated in the community, you can definitely send out a newsletter. We have a lot of communities that send out newsletters, and they're very successful. You can send this out. You can actually print it out and mail it out. You can send it out via email if you have homeowners that are willing to give you their email addresses. You can use social media as well. Social media, as we all know, can be a little bit tricky. So we want to make sure that if you do use social media, that the board is careful. We want to make sure that you're careful about what you post. We actually really designate trying to put one person, like a liaison, in charge of the account, someone that you trust, someone that you know is going to be reasonable, and that will go to the board for approval on their posts, if that's what you want, before they post it. You want to make sure that you are, posting as a business. You are a business and you need to behave in a business-like manner. So we do recommend it. You can be on Nextdoor, you can be on Facebook. You just want to make sure that you're exercising caution when you do that. We actually have a cheat sheet on this. Surprise, you're going to hear us talk about cheat sheets a lot, but we have a cheat sheet on social media and we recommend that you look at it because we do want to make sure that we're taking the correct approach, that we are making sure that people are comfortable looking at the association social media and also tamping down on any negativity in the social media, because that's definitely going to happen. And so we want to make sure that the board doesn't engage in that. We don't have board members that are engaging in that, and that the board presents a united front as part of the association. So definitely take a look at our cheat sheet, but we do recommend communications in between board meetings. We think it's helpful, especially if you're an association that maybe meets quarterly, or even less than that, or a lot of our associations don't meet during the summer at all, which is very, very common here in Arizona. And so you do want to keep communication with the homeowners in the meantime. So we definitely recommend it, but look at that cheat sheet on social media to make sure that you are approaching social media appropriately. I'm going to kick it back over to Beth now.
This particular board member said their bylaws have a 30-day limit on the rental of investment units in their complex. And this law has been, or this rule has been disregarded, but owners, has been disregarded by owners. And one particular unit is just a revolving door. And the owner claims that there are people in their unit for just 5 days, 3 days, 7 days, or just friends. So the people that are less than 30 days are friends just using the property, and not actually renters that are violating what their bylaws say. The board member says, I don't know what to do from here because the owner outright lies about the information. The board member spoke to the travelers themselves, and they're the ones who told us they were just renting it for a short period of time. How should I proceed from here? Okay, really good question. This is a very common question right now. So well, first thing is the 30-day provision in your bylaws, is that enforceable? Is this something that needs to be in the CC&Rs? It's possible that that could be challenged, just so you know. So it's a little shaky having the 30-day minimum rental limitation in your bylaws. I'm not saying that it's, it wouldn't upstand, some sort of a court challenge, but it would be better, significantly better if it was in your CC&Rs. But you can still use that it's in your original bylaws, and try to enforce it, of course. What I would recommend is that you keep a journal with the information that you have already obtained, in terms of the dates and times that you spoke to the travelers, what they said, how long they were there, to start documenting things. I would also look on online websites like VRBO and the other online websites that list properties. Lots of times you can find evidence of people violating, the documents. You can see people, will leave a review of the property. Hey, we had a great weekend, or, and take photos of that, because once we start contacting the owner, they'll remove a lot of that information. So I would document everything. I would either have the board or your attorney send the owner a letter with the documentation evidence, and, potentially consider doing fines. If it's a problem that's ongoing, you may want to consider doing a lawsuit. You probably just need to consult with your attorney to come up with the best plan. But the key things to remember are document this in writing, all the evidence that you have, including photographs of any online websites, names of people you talked with, etc. And then take legal action against the owner. The only way you will get the owner to comply with this is to, up the ante and let them know that, hey, there's going to be legal consequences and fines levied against you. And here's the evidence that we have, and it's sufficient for us to prevail. The next question that I'm going to cover is, can homeowners or board members volunteer to maintain the community landscaping instead of hiring a landscape company? So my advice on this would be no, please don't do this. This is not a good idea. Associations should be using licensed and bonded contractors. And I don't think the next question, the follow-up question I always get on this is, well, what if they sign a liability waiver? Would that protect the association? Possibly, but it's flimsy. Those types of waivers are not regularly upheld by courts. And, we just think it's best to treat this like a business, and have licensed and bonded contractors doing your landscaping. Okay, so I'm going to switch now to Lauren.
Okay, so our next question is it appropriate for board members to have separate discussions with each other and other homeowners regarding pending actions outside of a meeting, or should all these discussions be held in an open meeting? Basically, if less than a quorum of the board are discussing association issues, that's fine. You can definitely do that outside of a meeting. When you're talking with homeowners, we want to make sure you certainly can talk with homeowners about association issues outside of a meeting, but you just want to be careful in how you're talking, what you're talking about with the homeowners. So obviously you don't want to discuss anything that you've discussed in executive session. That obviously has to remain confidential. You want to make sure that you don't give away too much information necessarily the board's going to be discussing at the next meeting, or say something that the homeowner is going to take as some kind of like tacit approval for something that maybe they're requesting. So for example, if you have someone approach you about an architectural request, specifically their architectural request, you may say, oh, the board is leaning towards approving it, but you got to be careful because you don't know for sure that that's going to be approved. And so you want to wait until the entire board meets and discusses it at a meeting. So just be careful in what you say to the homeowners, but you can talk to them about association business outside of the meeting. Our next question is that the CC&Rs state that an association is responsible for the roofs, maintenance, repair, and replacement, and that they have a preferred vendor for a roofing contractor. The association has replaced approximately 17, basically some of the roofs out of the community, and now they have run out of money. So the board is wondering if they should pass a special assessment that the homeowners have to approve, or if they can have unit owners use the preferred vendor and pay for the roof replacement themselves and not have to be included in the special assessment. I do not think this is a great idea. The declaration says that the association is responsible for the maintenance of the roofs, and so the association is responsible for the maintenance of the roofs. I would not put that on the homeowners, even if they use your preferred vendor. It needs to be the association making sure that everything is taken care of. So it sounds like your option in this case, since the association has run out of money, is to really push that special assessment. We can assist you with that because special assessments can be hard to get passed, especially when they cost a lot of money. But you really want to emphasize that this is just a financial necessity and you need to make sure the roofs are maintained. So we can help you with that if you would like help with that.
Okay, the next question is it still legal to hold HOA board meetings on Zoom, or does there now have to be a physical room where homeowners can attend, even if most or all of the board is on video? So my recommendation on this is, and I think probably what this question leads to, is that there is something under the Condominium Act and the Planned Communities Act that says that the meeting has to take place in Arizona. Obviously I think that's going to be kind of outdated now due to the pandemic, where we weren't actually physically in the room for many years, for many months. So my feeling is it's still okay to hold, it's still legal for boards to hold meetings via Zoom. It's recommended by our firm that as we kind of navigate the rollout of, the vaccine, that you continue to have meetings on Zoom or have your meetings outside if that's possible. Do you have to actually have a physical room where the homeowners can attend? I don't think right now that it's mandatory just based upon the circumstances of the pandemic.
Okay, so our next question is about a neighborhood that is having a individual who is not in the community walk over to their grassy common area with his dog, and both he and the dog apparently defecate in front of the community. First of all, I'm very sorry this is happening to you. But second of all, you say that you've been told nothing can be done about this. Call the police. Every time you see this man doing this, without fail, call the police. Just because he's not necessarily exposing himself doesn't mean that it's legal to just poop wherever you want in a common area. So call the police every time. As horrible as this is, keep a log so you can tell the police when he's there, and the police should be able to address the situation for you. You can also, if you know who the individual is, send a cease and desist letter and tell him he's got to stop.
Okay, I'm going to do 3 quick questions. The first one is, next to our small townhome community, a 4-condo property is being built on a single family home lot. That property was surveyed this week and the stakes are within 2 or 3 feet of our association's wall. How could we qualify for an easement by necessity? So an easement is a right to use the area if we already own a foot or two already into the neighboring property. Realistically, we would need an easement of another foot to allow access to our community wall around the perimeter for future wall repair and replacement. Okay, so what I would recommend that you do here is you need to contact the city, town, or municipality that you live in and get information on the plans. You also could find out who the owner of this property is by going to the assessor's website. And you might be able to negotiate some sort of an easement across their property. However, it's something that, you know, it's their property technically. And I'm, you know, I don't believe, you know, based upon the information that's been provided to me, that there's any sort of prescriptive easement where you've got an easement by adverse possession. So the best thing that I would recommend is start out by contacting your neighbor. You can get their information by going to the assessor's office and start communicating with them as to what you want and what you need, and see if you can come to some sort of a mutual written agreement. Make sure that you get that agreement in writing, like I said, and then record it so that it's public record if you are able to negotiate anything. The next question is, the board recently passed a vote by a majority to allow resident owners to have pets, yet restrict pets for non-residents. So like tenants cannot have pets, but owners can have pets. Is this legally enforceable? It created some controversy within the community. If not legal, how should they go about undoing the vote? Okay, so I don't think it's a good idea to have different rules for owners versus non-owners. You know, obviously, if an owner wants to put a provision in their lease that the tenant can't have a pet, that's certainly the owner's prerogative. But, you know, I don't think this rule is a good idea, treating owners versus non-owners differently. What I would recommend is that the board reevaluate this at a future board meeting and just vote to rescind that rule. The next question is, are HOA management firms required by law to have a fiduciary duty to their clients? This is a condominium association that's asking this. Okay, so remember that the board of directors has a fiduciary duty to their owners under Arizona law, and that's in the Nonprofit Corporation Act. So the board has a duty of care, a duty of confidentiality, you know, a duty to act in the best interests of the owners. That's under the law in Arizona. The management company has a contractual duty to the association as outlined in the management contract, but they don't have a fiduciary duty under state law. They have a contractual duty. Whatever's in their contract, they have to abide by that. Okay, I'm going to switch over and let Lauren take the next few questions.
Can someone basically figure out who cast a vote in an election where you used secret ballots? Yes. Obviously, you can request the ballots and ask to review them. Because they're secret ballots, they're not going to have any kind of identifying information on them. But the association most likely, hopefully, has a list of who actually, which units cast a vote. You won't be able to see who they voted for, but you will be able to see which units cast a vote. So go to your board of directors, your manager, ask for that sheet, you know, noting who voted, and you should be able to figure out who cast a ballot that way. The next question is that this association CC&R state that they have to have an agenda before a meeting, and they're wondering if there is any kind of state law that requires that the agenda be available a certain number of days before a meeting. No, state law does also require that agendas be made available to members at the meeting, but the association is not required to make the agendas available prior to the meeting. We generally do recommend that you do try to make them available, just so homeowners have an idea of what you're going to discuss at the meeting. They can decide whether or not they want to attend. So if you can make it available, great. If you can't, you don't need to worry. You're not breaking the law or anything like that. You just need to make it available to members at the meeting, or if you're having a virtual meeting, put it up on the screen.
Question is, does state law require us to use a licensed contractor to do work for the association? The association that's asking this has 2 concrete slabs in their community pool area for new tables and shade structures, and they're having difficulty finding a licensed person for such a small job. We have 2 proposals from individuals with good references, but not licensed. I guess a couple questions that I would have. Well, first, it's always best to use licensed and bonded contractors. You know, that would be kind of a baseline. it's also the law. And so I don't know how much it's going to cost to do these 2 concrete slabs. But if it's, over a certain dollar limitation, I believe it's like $1,000, you are required by law to use a licensed and bonded contractor. So I would recommend you to ask your management company, reach out to your vendors, your attorney, other, landscaper, and see if they're aware of anybody that's licensed and bonded that might be able to help you with this project. Because I'm guessing it probably is over that dollar amount. Okay, the next question is a little bit longer. I'm going to try to summarize it if I can. This association has a strict 10% limit on rental properties. So that probably means that only 10% of the properties can be rented at one time. This threshold has been met for quite some time, meaning that, okay, so 10% of 10% of the lots are being rented. So this association created a waiting list for additional owners who want to rent out their homes. Per their rental policy, they're not allowing any new leases until we fall below the 10% threshold. Along the way, we keep discovering homes that are being rented out without approval in violation of our rental policy. And there seems to be a large influx of new people living in our community, but there have been few home sales. So it sounds like maybe the 10% limit on rental policies is, people are going around that. At this time, violating the rental policy is treated like any other CC&R violation with warnings and small fines. It doesn't do much to deter people from leasing their homes out. The first thing we want to do is create a separate violation and collection policy for illegal rentals, and we want to implement larger fines to escalate to legal action. So the question is, first, can we take legal action for this? And if so, what can we legally do? Well, first, just a quick comment on the 10% threshold. It's really hard to enforce these 10% limits when associations have them. It's basically almost impossible. So we don't ever recommend having those in your documents, but it looks like you have, I don't see if you have it in your CC&Rs or not, but to be enforceable, it would have to be in your CC&Rs. So if you do have it, it would be recommended that you have a lottery every year and that you pick people annually to be in that 10%. But I think kind of the larger issue here is that people aren't even following it, even though you have the 10%, you already have an issue. So, what can we do here? You're asking, can we take legal action? Yes, you can file a lawsuit, you can fine, you can create a larger fine policy for the violation of this. But before we do that, we're going to want to check to see if that provision in your documents is legally written, so it is actually enforceable. Can you deactivate owner's pool access cards? It depends. If your documents allow you for violations to do that, then yes, it's something you can do. Send out owner tenant information forms to get updated information. Yes, you can do that. Just make sure you follow what Arizona law allows you to request from them. And if you look at our cheat sheet on our website, which is located at mulcahylawfirm.com, we have a cheat sheet just on rental properties. And it has the information that you can request. So yes, you can ask them for that information. If they don't give it to you, you can charge them a nominal fine as outlined by the statute. Can we create a policy to allow us to reset the pool access cards annually so that we maybe update owner tenant information on an annual basis? Yes, you could do that. This would actually allow us to address the homes that are being rented out in violation of our CC&Rs and rental policy. Okay. So it looks like we've given you good legal direction. You can fine, you can, potentially limit their access to the common areas if your documents allow you to do that. Okay, the next question is, we have a vehicle on our association premises that has expired tabs. I'm guessing probably expired license plates from 2017. This vehicle is parked inside our association underground parking garage and has not moved since July 8th, 2017. It's an eyesore packed to the ceiling of items and boxes, and it's being used as storage. The unit owners own their own parking stalls, but they are collectively located in the underground garage, which is the association common property. Per city code, any vehicle parked on private property is not required to have current tabs as long as they do not drive on public roads. SPD, I'm guessing that Scottsdale Police Department, has confirmed they cannot cite the vehicle. However, they indicated that if our bylaws address abandonment, that would allow the association to fine or tow the owner. If we approve a board resolution, including that verbiage, would we then be able to enforce this as a violation if it's included in our enforcement policy and penalty schedule? Okay, this is kind of a doozy of a question. So you'd have to look at your bylaws to see how broad your rulemaking authority is on common areas. It's possible that you'd have the right to, pass rules regarding the parking of vehicles, in these common area stalls. I'm really not a big proponent of fining, of towing the owner rather, on these, because towing always results in lawsuits. So if you're going to tow the owner's vehicle for it being abandoned, it really needs to be in the CC&Rs giving you the right to tow. One thing I would just suggest, I'm guessing maybe you've already done this, reach out to the homeowner, call them up and see what's going on. Call him or her up and ask them why they're, doing this. And then you may want to reach out to your legal counsel to have them look at your documents and come up with a plan for you to help, get the vehicle owner to, make it so it's not so unsightly. And we've done this with other associations before. So I think we'll have some good suggestions for you once we're able to see your documents. Okay, I'm going to switch it over to Lauren.
I am going to take a couple of the next questions. Okay, so our next question is, I've heard that if an association is unable to get enough people to fill board positions, the state will take over the management and receivership. And they ask, what is receivership? So receivership does exist. The state doesn't necessarily just automatically move in or keep tabs on how many people are serving in your board and how many positions are open. The association essentially would have to petition for receivership. So basically, if you don't have enough people to fill vacant spots on your board, receivership really comes into play more so when nobody wants to be on the board, when you just cannot get anybody to help run the association. That's when you can go to a court, have them step in. They can appoint a receiver, which is someone who basically runs the business of the association for you. Keep in mind, a receiver gets paid. You would pay them to run your community for you and essentially operate as the board. It is always kind of a last resort. We would do everything we could to avoid it because we don't want you to have to pay for people to run your association. If you cannot find enough people to volunteer to be on the board, come talk to us. We can help, give you some ideas on how to incentivize people, get people to serve on the board. Maybe, they need to serve for shorter periods of time so they don't feel like it's a prison sentence, but we can definitely help you with that. But you're not at risk of the state coming in at any time and trying to impose a receivership. So the next question is a committee meeting the same under the open meeting law? Do you have a suggestion for a policy to work with the board chair and the community members on the community? So the open meeting law actually has kind of strange language when it comes to committee meetings. And what it says is that all board meetings have to be open to the membership, and regularly scheduled committee meetings need to be open to the membership. And they do not define what regularly scheduled means. So to be on the safe side, we take a semi-conservative approach and tell you probably should notice all of your committee meetings and have them be open to the membership. Kind of in the spirit of transparency, which the open meeting law is clearly intended to promote transparency in your community. Try to have the meeting open. The odds are you probably won't have a lot of people that show up at the meeting anyway. You can, give notice only 48 hours in advance, just like a board meeting, but we would recommend that. If you don't have regularly scheduled committee meetings, let's say they are just never at the same date and time, you meet very randomly, maybe whenever you get an architectural application, and that's rare, then you could potentially not notice the meeting. But if let's say you have a committee that meets every month, I would say that's regularly scheduled and that you would need to open that up to the membership and notice that meeting. So our next question is it permissible under the open meeting law for board members to communicate about board business of a non-emergency nature outside of an open meeting through a series of emails or meetings, each of which involves fewer than a quorum of the members, if the communications cumulatively involve all the members? So if you have less than a quorum of the board on an email, yes, you can do that. When you send things out via email, you kind of do breed basically the expectation that people are going to respond. And then you can start having a communication via email. And then guess what? A quorum of the board are communicating via email, and you're in violation of the open meeting law. So if you do send emails in between board meetings, here's what I recommend. I say that if you're going to send an email to the entire board, put a disclaimer at the bottom saying this is purely informational. Please only respond to me individually. Do not hit reply all on this email, or we can discuss it at a board meeting. If it's information that you want the board to have the board meeting, that's great for you to send it out ahead of time. Just like I said, include that disclaimer, say, hey, I don't want to get into a discussion via email. We need to have this discussion at the open meeting, but I want you to have this information. Or you can have one-on-one emails as long as that's less than a quorum of the board. So that is kind of your way around the open meeting law in between the meetings. But like I said, just be careful because it is very, very easy for people to hit reply all on your emails, and suddenly you're having a conversation that really should take place in an open meeting.
Okay, great. I have two quick questions. The first one is, how long has CFR Part 1, Subpart S of the federal rule regarding antenna and satellite dish installations in planned communities been in place? So since 1996, the OTARD rule has been in place. So actually that was right when I was starting to practice law. Who determines if certain antennas meet size limitations on the owner's property? Most of these antennas you can do like a visual check because you'll be able to see if it's 39 inches or less. I don't think I've ever really gotten into a disagreement or had an association get into a disagreement as to, does it meet the size limitations? Because usually a visual inspection, you can tell right away. Okay, the next question is kind of, it is lengthy and I'm not really even sure it's a question. So I'm just going to make a quick brief comment on it. So I think the gist of the question was talking about, when do state statutes take precedence over community documents? So we've got state statutes, Condominium Act, the Planned Communities Act, the Solar Panels Act, Solar Panels Law that pertains to use of solar panels, the Nonprofit Corporation Act. When do we look to those laws as, being more prevalent or more, the go-to when we're making a decision on something versus the association's documents? So really, we have to look at it on a case-by-case basis. Some laws are written in a way that says that, the state law controls, and the language that's used then is, unless the association's documents, state otherwise, this is, this will be the law. And so really what I would do is, if you're trying to determine if state law applies or if your documents apply, look at what the state law says on it. What type of language do they use? Do they say notwithstanding anything in your documents? That's going to mean state law is going to control. If it says unless the documents specifically provide, that means you need to look at your documents. And if it says something on it, then your documents are going to, be the controlling factor here. Again, this is why you have community association lawyers. These are hard questions for associations. So if you're confused about whether your CC&Rs apply or whether state law applies, if they conflict, make sure that you're reaching out to your legal counsel to answer that question. Okay, I'll switch it back over to Lauren.
Okay, so our next question is, a board of directors just voted to resolve a legal issue with a homeowner via arbitration. Is the now current board bound by that action, or can they pursue a different strategy? So the answer is, you are probably bound by the terms of that arbitration. You'd have to look at the language of the agreement that you specifically came to, but most arbitration is binding. And so you would be bound by the terms that you agreed to, because obviously the association agreed to be bound by those terms as a corporation, and you are now an agent of that corporation. So look at the language in it in the arbitration agreement, but very likely you are definitely bound by that language. Our next question is, in the past, homeowners have not always followed the CC&Rs bylaws and rules and regulations. And what is the best way to address this non-compliance going forward so as to not antagonize owners? Can you start with an in-person explanation of the documents and give them the opportunity to correct the situation, a formal letter? And then what if they refuse to take action or threaten to sue? So I would say I like your idea of taking a approach where you don't antagonize the owners, because if you have people who haven't been following the rules for a long time, they probably feel that they have a right to continue doing that. So I would say a great way to start is maybe a courtesy letter, something that lets them know, hey, here are the provisions of the CC&Rs and the bylaws that and rules and regulations that your property is actually in violation of. Show them the exact language so that they know that you're not just making this up. And then say, we notice that this is on your property. We want to give you a chance to correct this violation. A lot of the time, people honestly will not know that they are in violation of the CC&Rs. And so they'll correct the violation with a courtesy notice. And that's our initial hope. So definitely send a friendly notice, let them do that. But also you want to include language that says that if the violation isn't corrected, that the association can reserve the right to impose fines if the violation continues after a certain period of time. That way you're letting the owners know that even though you're trying to be friendly, that the association means business and that you're not afraid to use the legal remedies that are available to you. And so one of those options are fines. So you want to create a fine schedule, maybe you want to send that out to the homeowners and say, look, we're imposing this fine schedule. So if you don't cure these violations, you'll have a monetary penalty imposed against your property. And you may end up having to kind of threaten an injunctive relief lawsuit, or maybe file an action with the Arizona Department of Real Estate to try to get the owner to comply. Hopefully it won't come to that, but you do want to make owners aware that you have that ability so that they realize the association does have resources available to it to address these violations and that they do need to comply with the documents. We can help you draft that language or some kind of letter if you're having trouble with an owner who won't comply with the rules, but a courtesy letter is a great way to start. And I'm going to kick it back over to Beth.
Okay, great. I have two quick questions. Some board members refuse to adhere to and enforce our association's governing documents and refuse to maintain the association's common elements, continuing to kick the can down the road. We have deferred maintenance issues that can't be addressed due to lack of reserves and the board's reticence to doing a special assessment. We think this makes the association vulnerable, but some on the board feel that homeowners will never sue us because it'd only be like suing themselves. Is this the right thinking? Even though a homeowner could be assessed legal fees of the association, couldn't they be awarded damages to make up for that? So really good question. So you have a situation in this association where the board isn't enforcing the documents. There's deferred maintenance. They're refusing to do a special assessment. What can happen to the association? Well, of course, yes, they could be sued. And if the owner prevails, yes, they would be entitled to reasonable attorney's fees. Would they be awarded to damages? I really don't ever see damages, truthfully, unless there's something where they've actually been harmed, and they can prove that there's been harm to them. So the risk really is that the association is going to get involved in a lawsuit. And over time, if this continues to happen, what we see, happen is that either the board gets removed from office for, not living up to their fiduciary responsibilities, or we get new blood on the board and they start to shake things up and make things happen. And so, I think this association really needs to come up with a plan to address these issues because they're serious and they're not going to go away. Next question is, can an HOA make a rule saying racist stickers or pictures on cars parked in their community are not allowed? You're going to have to look at what your rulemaking authority is under your CC&Rs or your bylaws. And I don't know if these cars are parked on private property, like in a driveway, or if this is if they're parked in the common area spaces. And that's really going to be dependent on how broad your rulemaking authority is, whether or not you can regulate that. I think what the board may want to do is just put something in your newsletter, just reminding people that, stickers, potentially could be offensive to others, and just, recommend that, we really refrain from doing things like that. But remember, there's free speech and there may not be anything that we can do about this. And honestly, even if we did pass a rule on it, it's going to be one of those cases, it's going to be on the news for sure. So it may not be something that you want to pursue as an association. I'm going to switch it back over to Lauren.
Is it legal and appropriate for our management company to send each homeowner a form requesting their email addresses for the purpose of, less expensive communication, and as well as sending an association newsletter? And can they ask for the names of tenants and the length of any lease or rental agreement? Yes. It's fine to ask owners for their email addresses. They don't have to give them. They're not required to. We recommend including a statement in that letter, though, that says something that, the email addresses are only going to be used for official association purposes and that they're not going to be distributed to anybody else. The management company is also allowed to request under state law information regarding the tenancy. So they can ask for the contact or name of the adult tenants. They can ask for the length of the tenancy. They can also ask for any vehicle information, license plates, and just the make and model of any kind of tenant's vehicles. So it's absolutely fine for them to ask for that information. Our next question is, our community clubhouse is in need of an update and some maintenance, and the board has asked a clubhouse committee to work with the superintendent to obtain some bids, and then asks, to what degree should the board seek community involvement regarding the clubhouse updates? That is totally up to the board. There are plenty of boards that truly don't seek community involvement, mostly because they have homeowners who don't really want to be involved in the process. It sounds like you may have homeowners that do want to be involved in the process. And so what I would recommend that you do is, once you have, let's say you've narrowed it down to like 2 or 3 bids on the clubhouse and you know what you want it to look like, you could potentially distribute that to the homeowners and say, hey, come to this meeting, an open meeting or a virtual meeting, and give us your ideas or your thoughts on these designs, what you think would work and what you think don't. Don't send too many bids out, because that can just be too many cooks in the kitchen and too many people giving you their opinion. So try to narrow it down, and you can get homeowner input that way. But ultimately, it's going to come to what the board of directors wants to do. So it's really up to you.
Okay, great. I have 3 questions that I'm going to answer quickly. We have owners who would like to expand the width of their driveways, which would mean that they would be covering some of our common grounds. The board needs to know if we can authorize them to do this without deeding the portion of the common grounds to them. So first, I would not, as legal counsel for associations, be in favor of the board authorizing owners to allow, the driveway to be built on the common area, even if it's only, a small portion of the driveway. I would advise against that, number one. Number two, if the board were to do that, there would be a lot of different things that would need to be legally addressed, such as, does the board even have the legal authority to do that under the documents? Would we have to actually deed these areas to them? Likely we would. Would the plat have to be amended? All these are, sticky legal issues that would need to be addressed. The next question, if we implement a reserve contribution fee intended to be paid by new buyers only, and that estate planning title transfers are exempt, does this include transfers by beneficiary deed? Does this need to be spelled out in our documents, or is it assumed? Okay, so it sounds like you guys are doing like a capital contribution fee or reserve contribution fee. And I think Lauren talked about this previously a little bit on the first Fridays. So it all depends on how you word it. If you're going to have a reserve contribution fee for new buyers and you want to exempt estate planning title transfers, you should spell it out specifically that beneficiary deeds, owners that take title by beneficiary deed are not subject to the reserve contribution fee. And we have some language in our office, if you need help with that, that spells out every different angle on that. Please contact us if you need help. The next question is, how to best handle a board of directors who disparage neighbors in a board closed meeting? Should we have a code of ethics? So just the example that they gave is saying this owner is an alcoholic or this person's crazy. We'll be really careful on this would be my answer. Number one, you as a board could be sued for defamation for making comments like that. And you may want to consider having a code of ethics for your board. It's inappropriate that these type of comments are being made in a closed session or in an open session. We have a great cheat sheet on our website at mulcahylawfirm.com that talks about a code of ethics for associations, and you can look at that as a starting boilerplate and maybe even add something about no personal comments or attacks about individuals. could be added to that if it's not already in there. But I think you need to be careful on this. Associations do get sued for defamation, and this is a professional business. These type of comments are not appropriate in a closed meeting or an open meeting, or even to anyone else outside of a meeting. I'm going to switch it back to Lauren now.
Okay, so our next question is, an association is trying to amend their CC&Rs and bylaws, and they have a couple of members in their community who are mentally incapacitated and under the care of their children. And they want to know that if basically the child who's taking care of the parent can vote on the amendments, if they have to have power of attorney in order to do that. It basically, this kind of depends on the language of your governing documents. It depends on who actually can cast a vote. Very, very likely your governing documents are going to say that the people who have the ability to cast a vote are the record owners of the property, which very likely is still the individual who is mentally incapacitated. If you can get a document from the child that indicates they do have power of attorney and the ability to make decisions regarding, the homeowners association or the property, then yes, I think that they can cast a vote on behalf of their parent. If you don't have documentation like that, their vote could be challenged. If the child votes, that vote can be challenged because it's not an owner who cast a vote. So look at your documents. This may be something, honestly, that you want to have our office involved in so that we can make sure that the correct person is voting. Our next question is that an association that has a 5-member board, they have 1 vacancy and they have 13 owners. So they're asking what the requirements are for the annual meeting, what kind of notice needs to be given, and do they need a quorum to conduct business and take action? So without looking at your governing documents, I cannot tell you the exact requirements for your annual meeting. I know under state law, you need to hold an annual meeting at least once a year, but I don't know what your quorum is for that meeting. It really depends on what is in your governing documents. So you're going to want to review your bylaws and your CC&Rs to see what quorum is. It's very likely in your bylaws, and it will be a specific quorum for a member meeting. We can take a look at that for you if you need it. But in order to hold the meeting, you do need to have quorum. So you are going to have to make sure that there are a certain number of homeowners that are in attendance, either in person or via absentee ballot at that meeting. So you're going to want to review your governing documents to see what is needed. Notice is also required for the meeting, and notice needs to be given at least 10 days, but not more than 50 before an annual meeting, and it needs to be sent by mail or hand delivered. So if you need help with your annual meeting, contact us. We can definitely help you. We help associations with annual meetings all the time. Okay. Let's see, we've got one more question. If a member is not in good standing and cannot vote, do they count toward quorum? Yes, they do. Your governing documents very likely only say that an owner's right to vote can be suspended if they are not in good standing, but they still count for quorum.
Okay, I'm going to switch over and do 4 quick questions. Neighbor A has a tree with branches running through electrical lines. Neighbor B has A's branches overhanging his property. A refuses to let B trim the branches. Solution. Okay, so first of all, if anyone has branches running through electrical lines, you can contact the electric company and make a complaint, and they will either come out and trim them, or they will contact that owner to trim them. If an owner has branches overhanging on another owner's property, the nice way to handle it is to first ask the owner, please trim your branches back so they're not overhanging on my property. If they refuse to do so, Arizona law allows the owner who has the branches overhanging on their property to trim back the branches to the property line. Of course, try to be nice and work it out with the owner first. If they refuse, then you have the right to trim it back to your property line. The next question is, can you give me guidance regarding records retention for HOAs? We have a cheat sheet on this topic that is really helpful. It's at mulcahylawfirm.com. It's called records retention, I believe. And basically kind of the rule of thumb is like there's some documents that you keep forever, like your association's documents, meeting minutes, contracts that are still in force. There's some things that you can get rid of after 7 years, like old bank statements for your association. And why the 7 years? because, the statute of limitations is typically 6 years. So you can only be sued 6 years back. So we go through in detail on this cheat sheet, what can be kept, what must be kept for indefinitely, what should be kept for at least 7 years, et cetera. So I really suggest that you take a look at that cheat sheet on our webpage on records retention. Next question, must a board member chair every meeting of an architectural review committee? And what happens if the board member that is chair cannot attend an ARC meeting? So great question. So it basically just says that the board member has to chair the architectural committee. It doesn't say that they have to chair every meeting. So of course, best practices would be that the board member be attending, all meetings or a great super majority of the meetings. If they have to miss one or two, I don't think that should be a big issue. But if they can't attend any of them and they're just, a chair in name only, obviously that's not going to be appropriate. So I think if they miss one or two in a year, that's no big deal. But as long as they're still chairing the committee and they're still seeing the results, via the meeting minutes after the meeting, I think that's fine. But, they should be, if you're the chair of a committee, you really should be there every time. Next question, what recommendation would you provide when our association found out our previous property manager renewed our refuse contract in 2018 when they were replaced in 2016? Our prices went up by 33% in 2019 and again for this year. So I just want to make sure I'm clear. So the management company appears to have been replaced in 2016, but they somehow renewed it in 2018 on behalf of the association. I think there's an issue there. That the numbering on that is correct, that after they were fired, they renewed it. I think what I would recommend is get the contract out and get a copy of whatever contract that they agreed to. In order to sign a contract, you have to have authority. And so if they were not technically your management company, the contract could in fact be void. What we sometimes see is that something gets renewed by a management company while they're still managing the property and the board doesn't know anything about it. If that management company had a parent authority, it could potentially be enforceable for the association. So this is a weird one. You definitely want to talk to your legal counsel because it does appear that you have legal rights if the management company or the property manager renewed the contract when they were no longer managing you. Okay, I'm going to switch it over to Lauren.
Okay, so our next question is, an association's CC&Rs allow the association to collect attorney's fees, and the board wants to know if they can add the attorney's fees to a homeowner's account as the fees are incurred. And they want to know, what if the homeowner refuses to pay the legal fees, fines, or penalties, but continues to pay the assessments on time? So most associations do have the ability to basically charge legal fees back to homeowners for legal fees that were incurred to try to collect past due assessments. Some association documents also allow you to charge attorney's fees back to homeowners for enforcement issues, but it really, really depends on the language in your governing documents. So you're going to look at the specific language, and when it allows you to charge those fees to a homeowner, don't just charge them all and put them on the homeowner's account without looking at that language carefully. And if you are allowed to charge those fees to a homeowner and the homeowner doesn't pay, definitely keep them on the account, but you're going to want to have legal counsel look at your options to try to collect those fees. You might need to pursue a lawsuit against the owner. You might need to send them some letters reminding them that they owe those costs, but you definitely want to get legal counsel involved. So again, you can have somebody look at your documents and understand exactly how legal fees can be charged back to those homeowners and what options you have, because it really is going to depend on how many fees are owed by the owner and what those fees are for. So the next question is, how do you handle an owner that comes into an office when they're irate and loud and demanding to see documents of the corporation and wanting copies? It looks like basically this association does allow members to view the documents in the office. Do you need to allow copies? Yes. So Arizona has a records request law, and you can find this on a cheat sheet that we have on our website, that basically says that a homeowner can make a request to review records of the association, but you don't have to make those records available whenever the homeowner demands it. You have to make the records available within 10 business days. And so you can tell the owner, hey, come review these in our office. You don't have to send them to the homeowner. And if the homeowner comes and reviews them and says, I want copies, you are required to give them copies of the documents, but you can charge them 15 cents per page. So that is something that you'd be able to make a teeny bit of money off of. Something to consider too, you can see this on our cheat sheet. There are documents that you can withheld. There are documents like from your legal counsel, anything pertaining to ongoing litigation, meeting minutes for executive sessions. So look at that, our cheat sheets, that you can figure out exactly what documents you can withhold. And if you ever have a question about, this document seems iffy, can we withhold this? Can we not? Contact your legal counsel so that you don't withhold something that you should be giving to the homeowner and making available to them. Also, one last quick question. If the homeowner is being irate, or if you're ever concerned that they're becoming violent or just becoming very unreasonable or making you uncomfortable, ask them to leave the premise. Tell them, to give you their request in writing so that you can get everything together for them. Tell them that state law gives you 10 business days, but ask them to leave the office if they're making you uncomfortable. And if they really won't leave and they continue engaging in this really aggressive behavior, you may need to call the police. We don't want anyone to ever be in a situation where you feel unsafe. So our next question is, we have two different residents that have habitual parking violations in a condo complex. They're parking in other people's spaces, tow-away sites. They are parking trailers on sites. And it sounds like you're having their vehicles tagged, but it's not curbing the parking activity, and you're wondering if it's better to fine them. Definitely impose fines. Yeah, you want to make sure that they have some kind of monetary penalty, essentially, since they obviously are going to continue parking and the tagging is not doing anything. So definitely impose fines, send letters so that they are aware constantly that you are noticing this, that you're aware of the parking violation, and you will continue to impose fines. If it continues, we'd have to look at this in a case-by-case basis, but it may be something where we might need to go to the Arizona Department of Real Estate or an injunctive relief lawsuit. It's tricky with a violation like this because it's so temporary in nature. Obviously, it changes every time that they move the car. But if we could potentially establish a pattern, that might be something that we could maybe show to a court. So definitely send them violation letters and fine them. That is a great tool in your chest. The last question I'm going to answer is, let's see, we are a condo association that's under a master association, and there is stormwater drainage from one of the sub-association's buildings that runs downhill into a community property. Over the years, the water flow has been unintentionally blocked by natural changes in the landscaping on the community property. The water has backed up and caused damage to a unit. And it looks like you're getting resistance from the master association to allow you to make changes to allow the water flow the way that it was originally engineered. So what rights do you have? If it's common area that the master association is responsible for maintaining, it is their obligation to make sure that the water is flowing in a way that doesn't cause any kind of damage to any neighboring properties. So I would recommend, if you've already gotten some pushback from them, you may want to get legal counsel involved. We've been involved in situations like this in the past, where there are issues between a master and a sub. So you will want to get someone involved so that the master fully understands that they do have an obligation to maintain this land, and they need to make sure that it isn't maintained in a way that causes damage to any neighboring properties. If you can work it out amongst yourselves, that is fantastic. But if not, get legal counsel involved, because you do not want to be responsible for long-term damage to another property.
Okay, great. I'm going to finish up with the last three questions. Can the board pass a new CC&R rule to address one-time infrequent violation and then immediately fine a homeowner? Example would be backwashing a pool into the neighborhood. I hear the same question on trash cans, parking of RVs. So I think this is a very relevant question. So can we pass a rule that says, once you do this, it's an immediate fine? So the bottom line on this is no. Under Arizona law, there's a very specific procedure for fining an owner, and you have to provide notice of the violation. You have to give them an opportunity to be heard, and then you can levy the fine. So short answer, we can't make it an immediate fine. Now, there is an exception to this. If it's a habitual offender, what you can do is the first letter that you send to them, regarding the violation, let's say it's over backwashing your pool. I mean, that's going to be kind of like a one-time thing because that doesn't happen that often, but maybe it's parking, or maybe it's trash cans, or, RV issues. The letter can set it up that way and say that, for the first violation, you give notice of the violation, an opportunity to be heard, and then we levy the fine. After we've gone through that process once, we could say any additional violations of this will result in an automatic fine of X. That would be one way to set that up. Next question, under the state statutes for a document request, can you request the documents be sent to you digitally? Or does the management company only have to let you view them physically? So really good question. So when you're asking for books and records of the association via a document request, there's two ways that you can request them under the current language of the statute. You can ask to inspect them physically, which during the pandemic, that has been less likely for management companies to allow that. Or you can ask to see a copy of them. And the copy is going to be at the state mandated, rate of 15 cents per page. Can you request that they be sent to you digitally? Of course you can. And frankly, I advise our clients, our associations that we work with, and when I'm handling a records request, we just send it digitally if it's a small amount of documents. And we obviously don't charge them to do that. So I would say associations really should be looking for ways to help owners on this. And if you can pop something to somebody by email or digitally, you should be doing that and not charging them a fee to do that. So I think the statute at some point will change, and it will allow for, a required digital transfer if the owner requests it, but right now it doesn't. And the final question for today is, what do you do if you have a situation where common areas were not deeded to the HOA and the county now has lien holders for back taxes on these common areas? This is a problem we have seen many, many times over the years. So basically what typically happens is the developer, when they're in control of the property, the last thing that they do before they leave and move on to different property is they deed the common areas to the association's common areas to the association in a planned community. And sometimes they forget to do this. And it's a big problem because what happens is the taxes don't get paid typically because the tax bills aren't being sent to the association. And after 3 years, somebody buys the tax lien from the assessor's office, and then they can foreclose after 2 years of waiting for the statutory waiting period. I think it's either 2 or 3 years. And now the association is faced with a foreclosure of their lien on their own common areas. And I actually had this happen at an association where they had a pond or a lake, and the lake in the association was being foreclosed on because taxes had not been paid. Okay, so what are some things that you need to think about if you're in this situation? Number one, get an attorney involved for your association. We've handled these cases before. We can help your association. The first thing you need to do is get the common areas deeded to the correct party, the association. So you're gonna have to track down the developer and get the property deeded to the association. If you can't track down the developer, you may have to do a quitclaim lawsuit or a quiet title lawsuit. If you can't get the property quitclaim deeded to the association by the developer. So you may have to file a lawsuit to get the property in your name. I would not recommend just letting the property go to the person that has the lien, the tax lien. I think that's a very bad idea. You need to rectify this. This is something that you can't just ignore. And once you get the property in your name, then you want to make sure that the county gives you the preferential tax treatment that you get if you're a common area in the association. You'll be paying very low taxes. And then you're going to need to pay off who owns it, whatever the back taxes are, plus interest and maybe attorney's fees if they hired an attorney. So it's a sticky situation. It can be fixed. It's not something you should ignore if your common areas were not deeded to your association, or if, a lien holder has bought them at a assessor's tax lien sale. Okay, so closing remarks here. Thank you so much for joining us here today for our first virtual First Fridays. Thank you so much to our viewers for being here today. We started out with a 30-minute seminar, and we answered 49 questions in 1 hour and 17 minutes, which Lauren, I think is pretty impressive. Good job.
Great.
Please reach out to us and let us know if you enjoyed this new format. It obviously is easier for us to answer a large volume of questions in this manner, and we hope that you enjoyed listening in and hearing what some other associations have as issues, and maybe you might see those issues in the future and you'll be ready for them. So thank you again for being here today. I'd like to thank my team, Morgan, Yvonne, Lauren. All of you are awesome in getting this new format put together, and I am so lucky to have a team that's flexible and can try new things. So thanks, everybody. I'd like to do a special shout out to Morgan, who it's her birthday today. So thank you for being here on your birthday and helping us navigate our first virtual First Fridays. And just some closing remarks. Just don't forget that April, we have our 4th class of our spring 2021 virtual HOA Academy on Tuesday, April 20th. And we've had great attendance for those classes. Over 100 people attend and over 300 views of videos after the classes. This class on April 20th is going to be discussing how to effectively work with your vendors, which I know is a huge topic. So management companies, landscapers, lawyers, we're going to cover everybody, how to deal with problems, how to avoid problems, how to negotiate contracts, what signs of good management companies are, and, we'll give you the whole 411 on it. So I hope that you'll be able to join us on Tuesday, April 20th for our 4th class of the spring 2021 virtual HOA Academy. Thanks again for being here today. Happy Easter, happy Passover, and we look forward to seeing you on April 20th. Take care, everybody.